Please be seated. The sitting is open. La Cour se réunit.
The court meets this morning and will meet in the coming days to hear the oral statements and comments on the request for an advisory opinion that the United Nations General Assembly submitted to the court on the question of the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. I shall now recall the principal steps in the present advisory proceedings. On 30 December 2022, by Resolution 77/247, the General Assembly of the United Nations decided to request an advisory opinion from the Court. The text of this resolution was communicated to the Court by a letter from the Secretary-General of the UN, dated 17 January 2023, and received in the registry on 19 January 2023. I shall now ask the registrar to read from the operative paragraph of that resolution on the questions on which the Court is asked to render an advisory opinion. Question A. What are the legal consequences arising from the ongoing violation by Israel of the right of the Palestinian people to self-determination from its prolonged occupation, settlement and annexation of the Palestinian territory occupied since 1967, including measures aimed at altering the demographic composition, the character and status of the holy city of Jerusalem, and from its adoption of related discriminatory legislation and measures? Question B. How do the policies and practices of Israel referred to in paragraph 18a above affect the legal status of the occupation, and what are the legal consequences that arise for all states and the United Nations from this status? Thank you, says the President. By an order dated 3 February 2023, the Court decided that the United Nations and its member states, as well as the observer state of Palestine, were considered likely to be able to furnish information on the questions submitted to the Court for an advisory opinion, and fixed 25 July 2023 as the time limit within which written statements on the questions could be presented to the Court, and 25 October 2023 as the time limit within which states and organizations having presented written statements could submit written comments on the other written statements. Ruling on requests submitted subsequently by the League of Arab States, the Organization of Islamic Cooperation and the African Union, the Court decided that these three international organizations were likely to be able to furnish information on the questions submitted to the Court, and that consequently they could do so within the time limits fixed by the Court. In June 2023, the Secretary-General of the United Nations communicated to the Court a dossier of documents likely to throw light upon the questions formulated by the General Assembly. The dossier was placed on the Court's website. In addition to the dossier, new documents and several translations were communicated to the Court by the UN Secretariat in October 2023.
Registry in order of receipt by Turkey, Namibia, Luxembourg, Canada, Bangladesh, Jordan, Chile, Liechtenstein, Lebanon, Norway, Israel, Algeria, the League of Arab States, the Syrian Arab Republic, Palestine, the Organization of Islamic Cooperation, Egypt, Guyana, Japan, Saudi Arabia, Qatar, Switzerland, Spain, the Russian Federation, Italy, Yemen, the Maldives, the United Arab Emirates, Oman, the African Union, Pakistan, South Africa, the United Kingdom, Hungary, Brazil, France, Kuwait, the United States of America, China, the Gambia, Ireland, Belize, Bolivia, Cuba, Mauritius, Morocco, Czechia, Malaysia, Colombia, Indonesia, Guatemala, Nauru, Djibouti, Togo, Fiji, Senegal, and Zambia. Then, written comments were filed in the registry in order of receipt by Jordan, the Organization of Islamic Cooperation, Qatar, Belize, Bangladesh, Palestine, the United States of America, Indonesia, Chile, the League of Arab States, Egypt, Algeria, Guatemala, Namibia, and Pakistan. By letters dated October 18, 2023, the Registrar informed the United Nations, its member states, and the Observer State of Palestine, as well as the League of Arab States, the Organization of Islamic Cooperation, and the African Union, that hearings on the request for an advisory opinion would open on 19 February 2024. For purposes of the current oral proceedings, the following participants set out in speaking order will take the floor: Palestine, South Africa, Algeria, Saudi Arabia, the Kingdom of the Netherlands, Bangladesh, Belgium, Belize, Bolivia, Brazil, Chile, Colombia, Cuba, Egypt, the United Arab Emirates, the United States of America, the Russian Federation, France, the Gambia, Guyana, Hungary, China, the Islamic Republic of Iran, Iraq, Ireland, Japan, Jordan, Kuwait, Lebanon, Libya, Luxembourg, Malaysia, Mauritius, Namibia, Norway, Oman, Pakistan, Indonesia, Qatar, the United Kingdom, Slovenia, Sudan, Switzerland, the Syrian Arab Republic, Tunisia, Turkey, Zambia, the League of Arab States, the Organization of Islamic Cooperation, the African Union, Spain, Fiji, the Maldives, and the Comoros. This morning, the Court will hear the State of Palestine, which has been allocated a maximum speaking time of 3 hours. All the other participants in the oral proceedings over the next days will speak for a maximum of 30 minutes each. Before inviting Palestine to address the Court, I would add that, in accordance with Article 106 of its rules, the Court has decided that the written statements and written comments submitted in the current advisory proceedings are to be made accessible to the public after the opening of the present hearings. These written submissions will be posted on the Court's website at the end of each day for those participating to the hearings on that day. The text of the oral statements will also be placed on the Court's website. I now give the floor to His Excellency Mr. Riyad Maliki, Minister of Foreign Affairs and Expatriates of the State of Palestine. Your Excellency, you have the floor.
Mr. President, members of the Court, it is an honor and a great responsibility to appear before you on behalf of the people and State of Palestine in these historic proceedings. I stand before you as 2.3 million Palestinians in Gaza, half of them children, are besieged and bombed, killed and maimed, starved and displaced. As more than 3.5 million Palestinians in the West Bank, including East Jerusalem, are subjected to colonization of their territory and the racist violence that enables it. As 1.7 million Palestinians in Israel are treated as second-class citizens, as unwelcomed intruders in their ancestral land. As 7 million Palestine refugees continue to be denied their right to return to their land and homes. I stand before you as the entire Palestinian people continue to be denied their fundamental rights, their very existence negated. For over a century, The inalienable right of the Palestinian people to self-determination has been denied and violated. Palestine was not a land without a people. It was not. As Israeli leaders have described it, a wasteland. There was life on this land. There was a political life, a cultural life, a social life, a religious life. It had schools and universities, cinemas and cultural halls. It had villages and villagers, families and communities whose life was disrupted by the impact of a promise made thousands of miles away over 100 years ago. A breach of a sacred trust that relegated the indigenous people of the land to the status of non-Jewish communities, according them only civil and religious rights, denying their existence as a people and their rights as a nation, and paving the way for their dehumanization and mass expulsion from their homeland decades later. The United Nations enshrined in its charter the right of all peoples to self-determination and pledged to rid the world of the gravest breaches of this right, namely colonialism and apartheid. Yet, for decades, the Palestinian people have been denied this right and have endured both colonialism and apartheid. There are those who are outraged by the use of these words. They should instead be outraged by the reality we are living. This reality is known by every Palestinian, suffered by millions, generation after generation. It is a reality of the expulsion of the Palestinian people from their own land, not just during the 1948 Nakba, which led to the expulsion of up to 900,000 Palestinians, not just the expulsion of more than 400,000 Palestinians in 1967, but continually, including now, as I address you at this very moment. It is the indiscriminate maiming and killing of Palestinians. It means you can spend the entirety of your life as a refugee, denied your dignity and your right to return home. It means your life and family, your community and home are under constant threat. Your loved ones can be taken away and thrown in an Israeli jail, held there indefinitely. Your land can be stolen, colonized, and annexed without hesitation. Freedom is nowhere to be found. There is no safe haven. It means discrimination everywhere and no justice anywhere. It is a reality where Israel can destroy Gaza, killing tens of thousands of Palestinians, almost half of them children, leaving 1 million children starved, terrorized, and traumatized for life, orphaned of a mother, a father, or both, amputated and disabled, leaving nearly 2 million people displaced and desperate with nowhere to shelter from the onslaught. The genocide underway in Gaza is a result of decades of impunity and inaction. Ending Israel's impunity is a moral, political, and legal imperative. Successive Israeli governments have given the Palestinian people only 3 options: displacement, subjugation, or death. These are the choices: ethnic cleansing, apartheid, or genocide. But our people are here to stay. They have a right to live in freedom and dignity in their ancestral land. They will not forsake their rights. I thus implore you, as you hear the legal arguments, not to forget the Palestinian people. Not to forget that our people are struggling every day for their survival as individuals, families, communities, as a nation. That less than a month ago, this court ordered provisional measures in a landmark case brought by the Republic of South Africa against Israel under the Genocide Convention, an order that Israel continues to defy with impunity. For decades, Israel has occupied the Palestinian territory, committing violations that are inherent to its presence in our land and colonial objective. This occupation is annexationist and supremacist in nature. It is a deliberate, cynical perversion of international law. It is thus illegal. The only solution consistent with international law is for this illegal occupation to come to an immediate, unconditional, and total end. As you affirmed 20 years ago, the Palestinian people have the right to self-determination. It is an erga omnes right. It is non-negotiable, non-derogable. No occupying power, including Israel, can be granted a perpetual veto over the rights of the people it occupies. Allow me now to show you 5 maps. The first one is historic Palestine. This is the territory over which the Palestinian people should have been able to exercise their right to self-determination. Instead, the General Assembly recommended the partition of Palestine, ignoring the will of our people, as shown in the second map. With the Nakba that ensued, over 2/3 of our people were systematically and forcibly expelled by Israel. And 3/4 of Palestine became Israel, as shown in the third map. This was the start of the Nakba, the dispossession, the displacement and replacement of our people, the denial of rights and discrimination that continues to this very day. In 1967, Israel then occupied the remainder of Palestine, and from the first day of its occupation, started colonizing and annexing the land with the aim of making its occupation irreversible. It left us with a collection of disconnected Bantustans, preventing the independence of our state, as shown in map 4. Israel wanted the geography of Palestine, but not its demography. So it kept pushing our people out of their homes, out of their land. Here is the 5th map. It was displayed by Israel's Prime Minister to the General Assembly last September. He called this the new Middle East. There is no Palestine at all on this map, only Israel, comprised of all the land from the Jordan River to the Mediterranean Sea. This shows you what the prolonged, continuous Israeli occupation of Palestine is intended to accomplish: the complete disappearance of Palestine and the destruction of the Palestinian people. There can be no justification for these injustices and indignities. Allowing them to continue is unacceptable and inexcusable. Acquisition of territory by force, persecution, racial discrimination and apartheid against the people, denial of self-determination are all grave violations of the most fundamental norms of international law. There is a legal and moral obligation to bring them to a prompt end. Mr. President, members of the court, the State of Palestine reaffirms its unwavering commitment to the rule of international law, which must finally prevail. The force of the law must prevail over the unlawful use of force. We said years ago that we made a choice: justice, not vengeance. But justice delayed is justice denied. And the Palestinian people have been denied justice for far too long. We believe in the universal principles crafted over decades to save successive generations from the scourge of war and oppression. It is time to put an end to the double standards that have kept our people captive for far too long. International law must be applied to all states without exception. No state can be absolved of its obligations under the law, and no people can be deprived of its protection. Palestine legitimately seeks the fulfillment of the rights of our people, including the independence of the State of Palestine on the pre-1967 borders, with East Jerusalem as its capital, in accordance with international law and United Nations resolutions. This is the historical compromise we agreed to. A just and lasting solution with two democratic states, Palestine and Israel, living side by side in peace and security. We seek peace, which can only be rooted in justice. When we committed to the peace process 3 decades ago, we did it in the belief and expectation that international law would finally be upheld, not that this process would witness its continued breach. We did so expecting that the rights of our people would finally be fulfilled, not further denied. By determining the law and the obligations of all states and organizations, this court can help chart a path for peace, anchored in justice and respecting international law. It has taken the Palestinian people decades of painful struggle to stand before you today. We appeal to the court to uphold our rights to self-determination, return, and all other human rights, including by declaring that the Israeli occupation is illegal and must end immediately, totally and unconditionally. Mr. President, members of the court, I will be followed today by 6 speakers on behalf of the State of Palestine. First will be Professor Andreas Zimmerman, who will address the court's jurisdiction to answer the General Assembly's questions and the absence of compelling reasons that might lead the court to decline to do so. Next will be Mr. Paul Reichler, who will demonstrate the illegality of Israel's prolonged occupation, because its annexation of Palestinian territory, including through widespread colonization, is intended to be permanent, in violation of the prohibition of the acquisition of territory by force. The next speaker will be Ambassador Namira Negm, who will address the system of persecution, racial discrimination and apartheid that Israel is imposing over the Palestinian people as a means of maintaining its control over the land by the subjugation of the indigenous Palestinian people. She will be followed by Professor Philip Sands, who will demonstrate how Israel's dispossession, displacement and replacement of the Palestinian people and discrimination against them has led to the wholesale denial of their inalienable right to self-determination. The court will then be addressed by Professor Alain Bellet, who will identify the legal consequences that follow from Israel's grave and ongoing violations of peremptory norms. These legal consequences necessarily include the obligation to bring this unlawful occupation to an end and to dismantle the colonial and supremacist architecture, legal and physical, that Israel has consolidated over decades. The final speaker of the State of Palestine will be Minister Riyad Mansour, our permanent representative to the United Nations. Minister Mansour will focus on the permanent responsibility of the United Nations and the obligations of all states to bring this injustice to a swift end, so as to uphold the laws, fulfill the Palestinian rights, and achieve a just peace for all. Many states will also stand before this court, informed by their own history of occupation, colonialism, and apartheid. They will stand here on principle to defend the international law-based order. And millions around the world will be watching, hoping that their faith in the international system can be restored, and that the Palestinian people will not be abandoned or discarded as expendable. Palestine remains the greatest test of the credibility of this international law-based order, a test humanity cannot afford to fail. Mr. President, members of the court, the state of Palestine expresses its fullest confidence that you will discharge the sacred duties entrusted to you with the wisdom, fairness, and justice that the world expects and needs of you. I thank you for the honor of addressing you, and I now request, Mr. President, the court to call on Professor Zimmerman. Thank you.
I thank His Excellency Mr. Maliki for his opening statement. I now give the floor to Professor Andreas Zimmerman. You have the floor, Professor.
Merci, Monsieur le Président. Mr. President, members of the court, let me start by expressing my honor to appear once again before the court. This is even more true this time, since the current proceedings address issues that have been of utmost relevance for the international community for decades, and indeed for the United Nations since its very inception. These issues lie at the very heart of the organization's ability to achieve international peace and security, now more than ever. I will present Palestine's arguments on jurisdiction and admissibility. I can and will be succinct, as there is no doubt that the court has jurisdiction to give the requested opinion, and that there are no compelling reasons for the court to decline to issue the requested opinion. Rather, to the contrary, compelling positive reasons exist for the court to address the legal questions referred to it, as the court's legal determinations will assist all parties as to the legal parameters that must be adhered to. The court's determinations are both urgent and relevant, given Israel's manifold violations of preemptory norms of international law, which continue and intensify on a daily basis. Mr. President, the court clearly has jurisdiction to provide the requested opinion. The General Assembly is obviously competent to request the opinion in line with Article 96(1) of the Charter. Moreover, Resolution 77-247 was adopted by a clear majority and in full compliance with both the requirements of the Charter and the Assembly's Rules of Procedure. The questions posed by the General Assembly are also plainly legal in character. And as the Court has repeatedly and consistently confirmed in its jurisprudence, the fact that the questions may have political implications is irrelevant and does not bar the Court from fulfilling its essential judicial function. Further, there is no reason, let alone a compelling one, for the Court to decline to issue the requested opinion. On the contrary, manifold reasons exist which confirm that an answer by the Court to these questions is of utmost importance for the General Assembly, the United Nations at large, and the international community as a whole. First, the questions concern serious breaches of jus cogens and erga omnes norms. As my colleagues will show, those breaches by Israel include violations of the prohibition of acquisition of territory by force, the prohibition of racial discrimination and apartheid, the denial of the right of self-determination, as well as other egregious violations of international human rights and humanitarian law of the same character. Accordingly, all states, as well as the United Nations in toto, have a legally protected interest in having those violations in both their individual and cumulative manifestations, as well as their legal consequences laid out and clarified by the Court, so as to guide them in their future actions. Second, the questions concern the United Nations' continuous responsibility for resolving the question of Palestine. This responsibility stems from its duties relating to matters of international peace and security arising under the Charter and, as the Court put it, quote, has its origin in the mandate and the partition resolution concerning Palestine, end quote. This responsibility continues as confirmed by the unequivocal and contemporary practice of the General Assembly, the Security Council, as well as other United Nations organs and bodies. And as the Court has previously reiterated in its Wall Advisory opinion, there exists, and I quote, a permanent responsibility of the United Nations towards the question of Palestine until the question is resolved in all its aspects in a satisfactory manner in accordance with international legitimacy, end quote. The questions put before the Court by the Assembly thus seek the Court's legal guidance on matters of fundamental and long-standing importance and concern to the United Nations. Third, all of the grounds for declining to issue an opinion suggested in the submissions of a few states fall far short of constituting compelling reasons that must exist for the Court to refrain from answering the General Assembly's questions. Some of these submissions oppose the advisory opinion because of the purported existence of a negotiation framework or of bilateral negotiations. However, none of these considerations constitutes a reasonable basis for the Court to refuse the General Assembly's request. To the contrary, an opinion from the Court will assist in these negotiations by confirming the applicable international legal framework as affirmed in United Nations resolutions in order to reach a just and peaceful solution. As a matter of fact, there exist at least three reasons why the Court should not be deterred from answering the GA's questions on that basis. First, Israel has repeatedly refused, and to this very day, to engage in meaningful negotiations with Palestine on the basis of international law and United Nations resolutions. This is reflected in repeated statements, including, most recently, by the Israeli Prime Minister and other high-ranking Israeli officials. The mere hypothetical possibility of future negotiations cannot thus be used as a mere pretext for avoiding the application of international law to this crucial matter, or for avoiding responsibility for ongoing breaches of preemptory norms of international law. Israel has made it clear that it wants and will tolerate only one state, Israel, between the Mediterranean Sea and the Jordan River. This is confirmed inter alia by the map displayed by the Israeli Prime Minister in his speech before the General Assembly of 22 September 2023 that you have already seen, as well as by his November 2023 statement where the Israeli Prime Minister said that he was proud to have prevented the establishment of a Palestinian state. But these statements of Israel's head of government have not been empty words. Rather, they are reflected in concrete policy decisions and measures on the ground undertaken by Israel for decades. Inter alia, when faced with the attempt by Palestine to initiate the conciliation procedure under Articles 11 and 12 third, it was Israel that consistently and continuously rejected any meaningful attempt to bring to an end, by way of negotiations under the auspices of the ad hoc commission set up under Article 12 third, its entrenched system of racial discrimination inherent in its occupation regime. Second, and significantly, the Security Council has repeatedly called for a peaceful settlement of the question of Palestine based on international law. It renewed this call only 2 months ago in December 2023 in its resolution 2720, when reiterating that a solution to the conflict must be, and I quote the Council, consistent with international law and relevant UN resolutions, end quote. The Court's opinion can thus only contribute to achieving the peaceful settlement of the question of Palestine called for by the Security Council. your opinion, will clarify the legal rights and obligations of Israel, of Palestine, of third states and of the United Nations to be reflected in a settlement that is truly consistent with international law. Thus, the Court's opinion will also contribute to upholding the international rule of law at large. In that regard, let me remind you, members of the Court, that this is precisely what the Court's advisory opinion in the Chagos proceedings achieved. By clarifying the relevant legal rules, your opinion, broke the deadlock that had precluded negotiations. The advisory opinion, your opinion, led the United Kingdom to agree to negotiate with Mauritius for the first time on the basis of Mauritius' sovereignty over the disputed territory. Third, the General Assembly, when deciding upon the request for the current advisory opinion, was acutely aware of the claim that such request would somehow purportedly undermine the chances of future negotiations. Nevertheless, the General Assembly decided to ask for the Court's legal determination anyway. The General Assembly thus found that this argument had no merit. To the contrary, the GA considered that the Court's opinion would be helpful as to future steps to be taken by the political organs of the United Nations, as well as by all states. In line with your role as one of the principal organs of the organization, as envisaged in Article 7 of the Charter, the Court ought not now set aside this considered decision of the General Assembly. Members of the Court, the mere hypothetical chance of possible future negotiations cannot and ought not prevent the Court from rendering its opinion. If this were the case, quod non, a reluctant state wishing to bar the Court from exercising its judicial function could unilaterally prevent the matter from reaching the Court by simply insisting on the mere possibility of negotiations. This would curtail the General Assembly's right to receive legal assistance from the Court, and to do so even in a situation where the General Assembly, making the request, determined that such opinion by the Court would be needed for the exercise of its own function. Such approach finds no basis in the wording of the Charter or the Court statute either. It would unduly limit the right of the political organs of the United Nations to request an opinion from the Court on any, as the wording has it, on any legal question, as both 96(1) Charter and 65 of the Court statute provide unequivocally. Mr. President, members of the Court, let me conclude. The catastrophic developments of recent months in the Gaza Strip confirm that the matters put to the Court by the General Assembly are, if ever there was need, not mere bilateral issues. Rather, they are issues of grave consequence for the maintenance of international peace and security. They are thus of immense concern for the international community at large, where the Court's legal guidance is desperately needed. All of these aforementioned considerations corroborate that in the present proceedings, as indeed in each and every previous advisory proceedings that had come before this Court, there are no reasons, no compelling reasons to prevent the Court from rendering its opinion. Rather, Palestine invites the Court to fulfill its duty of providing its legal determination to the General Assembly by answering the legal questions put to it. In so doing, you will assist all states, as well as the United Nations, in furthering respect for the international rule of law, the fulfillment of the inalienable rights of the Palestinian people, and a just and peaceful solution in accordance with international law. Members of the Court, I thank you for your kind attention and would now kindly ask you, Mr. President, to call upon Mr. Reichler to take the floor. Thank you.
I thank Professor Zimmerman. I now give the floor to Mr. Paul Reichler. You have the floor, Mr. Reichler.
Mr. President, members of the Court, it is an honor for me to appear before you and a privilege to speak on behalf of the State of Palestine. I will address the legality of Israel's prolonged occupation, annexation, and settlement of the occupied Palestinian territory. In so doing, I will identify the elements that determine whether and in what circumstances a belligerent occupation is or becomes unlawful under international law. I will then review the evidence to assess whether those elements are present here. And I will show that based on the applicable law and the well-established and undisputed facts, Israel's 56-year occupation of Palestinian territory is manifestly and gravely unlawful, and that international law requires that it be brought to an end completely and unconditionally. The applicable rule of law is straightforward. As Pictet wrote in 1958, occupation is essentially a temporary situation. This remains the law. In December 2022, the General Assembly, in Resolution 77/126, recognized that the occupation of a territory is to be a temporary de facto situation, whereby the occupying power can neither claim possession nor exert its sovereignty over the territory it occupies. This rule is neatly explained in the written statement of Switzerland. The laws of occupation are built on the idea that occupation is only a temporary situation. They are based on four fundamental principles. One, the occupying power does not acquire sovereignty over the territory it occupies. Two, the occupying power must maintain the status quo ante and must not take any measures which might bring about permanent changes. The law is thus crystal clear. Occupation can only be a temporary state of affairs. A permanent occupation is a legal oxymoron. Mr. President, what makes Israel's ongoing occupation of the Palestinian territory unlawful is precisely its permanent character. And what demonstrates its permanence are, one, Israel's de jure and de facto annexation of Jerusalem and the West Bank. Two, its claims of sovereignty over these areas, which it refers to by their biblical names, Judea and Samaria, and considers integral parts of the state of Israel. Three, its establishment of hundreds of permanent Israeli settlements, with over 700,000 Israeli settlers who have been promised by successive Israeli governments that they will never be removed. And four, the multitude of official statements and documents that openly declare Israel's intention to incorporate all of the occupied territory east of the Green Line into the state of Israel as a permanent part of a single Jewish state extending from the Jordan River to the Mediterranean Sea. As I will show you, the evidence is overwhelming and leaves no room for serious dispute about Israel's actions or its intentions. As Israel's cabinet secretary wrote in June of last year, quote, Judea and Samaria were not seized from a sovereign state recognized by international law, and the state of Israel has a right to impose its sovereignty over these areas, as they comprise the cradle of history of the Jewish people and are an inseparable part of the land of Israel. as purported legal authority, the cabinet secretary invoked the first book of Maccabees, written in the year 100 BC, chapter 15, verse 33. It is not a foreign land we have taken, nor have we seized the property of foreigners, but only our ancestral heritage, which for a time had been unjustly occupied by our enemies. This was followed in August of last year by a message broadcast on Israel Army Radio by Israel's heritage minister. Sovereignty must be extended within the borders of the West Bank, and the most prudent way to create international recognition that this place is ours. There is no green line. It is a fictitious line that creates a distorted reality and must be erased. In September 2023, Israel's prime minister literally erased the green line in his presentation to the United Nations General Assembly. As you saw earlier, he depicted the state of Israel as extending from the Jordan River to the Mediterranean Sea, eliminating not only the green line, but all traces of Palestine. This was no oversight. It was an act of the head of government with all the attribution that it implies. The same message was delivered by Israel's finance minister in Paris 6 months earlier, when he denied the existence of Palestine and declared that Palestinians do not constitute a people. Previously, he said, quote, "We are here to stay. We will make it clear that our national ambition for a Jewish state from the river to the sea is an accomplished fact, a fact not open to discussion or negotiation." This has been Israel's consistent position. Here is the map of Israel produced by its armed forces and published by the government in 2021. One state, Israel, from the river to the sea. There is no green line. There is no Palestine. Instead, Palestine has been replaced by Judea and Samaria, which, according to Israel's highest officials, are now integral parts of the state of Israel. As these official statements and maps demonstrate, Israel makes no secret of its intention to retain permanently the entire area east of the Green Line. Its annexation of occupied Palestinian territory began in 1967 with legislation annexing East Jerusalem, which Israel increased 11-fold in size to incorporate not only the Holy City, but also vast areas of the West Bank surrounding the city. Its defense minister, Moshe Dayan, declared at the time, "The Israel Defense Forces have liberated Jerusalem. We have returned to this most sacred shrine, never to part from it again." In 1990, the Israeli cabinet instructed the foreign minister to notify the Secretary General of the United Nations that Jerusalem is not in any part occupied territory. It is the sovereign capital of Israel. In June 1996, the guidelines of the incoming Israeli government stated, Jerusalem, the capital of Israel, is one city, whole and undivided, and will remain forever under Israel's sovereignty. More recently, in assuming office in December 2022, the current prime minister declared that the Jewish people are not occupiers in their own land, nor occupiers in our eternal capital, Jerusalem. As these official statements make clear, Israel's dominion over Jerusalem and the incorporated area of the West Bank is not intended to be temporary. It has been repeatedly proclaimed by Israel's highest authorities to be eternal. In furtherance of this end, more than 230,000 Israeli Jewish settlers, encouraged, subsidized, and protected by the Israeli government and occupation forces, have been installed in East Jerusalem, dramatically altering the demographic composition of the Holy City by creating an Israeli Jewish majority. Israel has been equally clear in declaring its permanence in the West Bank, where more than 465,000 Israeli Jewish settlers have been implanted, with the support of every Israeli government since 1967, in over 270 ever-expanding settlements spread throughout this territory in what can only be described as a vast colonial enterprise. These settlements, whose accelerated growth and distribution over the years are illustrated on your screens now, are a key instrument of Israel's annexation of the West Bank. This is both their purpose and their effect. As the Secretary General reported to the General Assembly in 2015, occupation is supposed to be temporary because the annexation or acquisition of territory by force is strictly prohibited under international law. In the West Bank, including East Jerusalem, the establishment and maintenance of the settlements amount to a slow but steady annexation of the occupied Palestinian territory. Israel has made no secret of the intended permanence of these settlements. In 2010, Prime Minister Netanyahu told Israeli settlers in the West Bank, "Our message is clear. We are planting here. We will stay here. We will build here. This place will be an inseparable part of the state of Israel for eternity." In August 2019, the Prime Minister announced, "The time has come to apply Israeli sovereignty over the Jordan Valley and to also arrange the status of all Jewish communities in Judea and Samaria. They will be part of the state of Israel." In January 2020, Israel's Defense Minister, Naftali Bennett, declared, "Our objective is that within a short amount of time, we will apply sovereignty to all of Area C, not just the settlements, not just this block or another." This area, which is depicted in red on your screens now, comprises over 61% of the West Bank. The defense minister proclaimed, "I solemnly declare that Area C belongs to Israel." This area includes the Jordan Valley, which is the water reservoir, the breadbasket, and the source of life for the entire West Bank. In December 2022, the guiding principles of the incoming Israeli government declared, "The Jewish people have an exclusive and indisputable right to all parts of the land of Israel. The government will promote and develop the settlement of all parts of the land of Israel, the Galilee, the Negev, the Golan, and Judea and Samaria." The coalition agreement between the political parties that formed the government included this pledge: the Prime Minister will lead the formulation and promotion of policy in which sovereignty will be applied in Judea and Samaria, while choosing the timing and weighing all the national and international interests of the State of Israel. General Assembly Resolution 77/126 was adopted on 12 December 2022, just as the current Israeli government was assuming office. The resolution pointedly recalled, quote, "the principle of the inadmissibility of the acquisition of land by force, and therefore the illegality of the annexation of any part of the occupied Palestinian territory, including East Jerusalem, which constitutes a breach of international law." And the resolution condemned, quote, Israel's annexation of land, whether de facto or through national legislation. Israel has thoroughly disregarded Resolution 77/126, just as it disregarded all prior General Assembly and Security Council resolutions declaring illegal the annexation of any part of the occupied Palestinian territory and the establishment of Israeli settlements there. These include, but are by no means limited to, Security Council Resolution 252 of 1968, declaring Israel's acquisition of territory by military conquest inadmissible. Resolution 476 of 1980, which reaffirmed the overriding necessity for ending the prolonged occupation of Arab territories in 1980, and strongly deplored the refusal of Israel to comply with the relevant resolutions of the Security Council and the General Assembly. Resolution 478 of 1980, which determined that all legislative and administrative measures and actions taken by Israel to alter the character and status of the Holy City of Jerusalem, and particularly the basic law in Jerusalem, are null and void and must be rescinded forthwith. Resolution 2334 of 2016, which reaffirmed the inadmissibility of the acquisition of territory by force and condemned all measures aimed at altering the demographic composition, character, and status of the Palestinian territory occupied since 1967, including, inter alia, the construction and expansion of settlements, transfer of Israeli settlers, confiscation of land, demolition of homes, and displacement of Palestinian submissions, and at least 28 General Assembly resolutions which expressly condemned Israel's annexation of Jerusalem and the West Bank. Israel has also blatantly disregarded the obligations reflected in the court's 2004 advisory opinion in the wall case. Since then, instead of dismantling the wall, Israel has extended it from a length of 190 kilometers to more than 460 kilometers, encompassing hundreds of additional square kilometers of Palestinian land and incorporating it into the State of Israel. In its advisory opinion, the court expressed concern lest, quote, the construction of the wall and its associated regime create a fait accompli on the ground that could well become permanent, in which case, and notwithstanding the formal characterization of the wall by Israel, it would be tantamount to de facto annexation. And that is precisely what has happened over the past 20 years, not only within the expanded confines of the wall, but all across the West Bank, most of which has now been annexed de facto by Israel. In 2022, the report of the United Nations International Commission of Inquiry concluded Israel treats the occupation as a permanent fixture and has, for all intents and purposes, annexed parts of the West Bank. The International Court of Justice anticipated such a scenario in its 2004 advisory opinion. This has now become the reality. The Special Rapporteur on Human Rights in the occupied Palestinian territory reached the same conclusion. The occupation by Israel has been conducted in profound defiance of international law. Its 55-year-old occupation burst through the restraints of temporariness long ago. Israel has progressively engaged in the de jure and de facto annexation of occupied territory. Mr. President, Israel's ongoing annexation Israel has progressively engaged in the de jure and de facto annexation of occupied territory. Mr. President, Israel's ongoing annexation of the West Bank accelerated in 2023, with the largest ever expansion of settlements in the territory. 22 new settlements were authorized, and more than 16,000 new housing units were built, funded, or planned by Israeli authorities. As explained by Israel's finance minister, quote, "The construction boom in Judea and Samaria and all over our country continues. We will continue to develop the settlements and strengthen the Israeli hold on the territory." In developing its settlements, Israel has invested heavily in the infrastructure needed to supply them with water and electric power, as well as a network of roads and highways to connect them to one another and to Israel itself. These investments in the hundreds of millions of dollars attest to the intended permanent character of the settlements. The roads, which Palestinians are forbidden to use, and a pervasive system of roadblocks and checkpoints prevent Palestinians, but not Israeli settlers, from moving from place to place in the West Bank. And they isolate Palestinian communities by cutting them off from one another. Israel's settlement expansion has thus both uprooted Palestinians from their homes to make room for new settlements and forced them to live in disconnected and non-contiguous enclaves, which the special rapporteur has called, quote, "a fragmented archipelago of 165 disparate patches of land." This achieves the fundamental objective of the occupation: permanent acquisition of the maximum amount of Palestinian territory with the minimum number of Palestinians in it. In furtherance of this objective, and with increasing frequency, armed groups of settlers, supported by Israel's occupation forces and encouraged by government ministers, have violently expelled thousands of peaceful Palestinian civilians from their ancestral villages and lands. A UN fact-finding mission confirmed, quote, "The motivation behind this violence and the intimidation against the Palestinians and their properties is to drive the local populations away from their lands and allow the settlements to expand." The UN High Commissioner for Human Rights reported in March 2023, quote, "Settler violence further intensified, reaching the highest levels ever recorded by the United Nations." In November 2023, the High Commissioner warned that the situation had further deteriorated with, quote, "a sharp increase in settler violence and takeover of land across the West Bank. Since 7 October, he continued, nearly 1,000 Palestinians from at least 15 herding communities have been forced from their homes." The Secretary General, in his most recent report, issued on 25 October 2023, expressly linked the expansion of Israeli settlements to the permanent acquisition of Palestinian territory. Successive Israeli governments have consistently advanced and implemented policies of settlement expansion and takeover of Palestinian land. The policies of the current government in this regard are aligned to an unprecedented extent with the goals of the Israeli settler movement to expand long-term control over the occupied West Bank, including East Jerusalem, and in practice, to further integrate those areas within the territory of the State of Israel. Mr. President, members of the Court, taking account of this evidence as well as that described in the State of Palestine's 2 written submissions, I turn to the law and how it applies to this occupation. The written statement of Switzerland is once again directly on point. It highlights the distinction between the law of occupation and the legality of a particular occupation. The law of occupation and the legality of occupation are 2 different questions. The law of occupation applies independently of the question of the legality of the occupation. Occupation is a situation subject to international humanitarian law, whereas its legality is covered by the United Nations Charter. In relation to the legality of the occupation under the Charter, Switzerland observes, quote, "The United Nations has consistently reaffirmed the principle of the inadmissibility of the acquisition of territory by force and condemned Israeli measures aimed at modifying the demographic composition, the character and the status of Jerusalem and the occupied Palestinian territory as a whole. Notably, the construction and extension of settlements, the transfer of Israeli settlements, the confiscation of land, the demolition of homes, and the displacement of Palestinian civilians." In Switzerland's view, quote, "The measures taken by Israel in the occupied Palestinian territory lead to fundamental changes, particularly demographic changes, that can have a permanent character. In such circumstances, Switzerland expressly invites the court, quote, to rule on the consequences of the permanent character of the measures taken by Israel in the occupied Palestinian territory as to the status of the occupation under general international law, in particular, the Charter of the United Nations." Many states agree with this approach. France, too, underscores the temporary character of lawful occupation. This is a requirement that Israel's occupation of Palestinian territory plainly fails to meet. As France states, if the restrictions authorized by a regime of occupation were justifiable in the period following the military operations, they are not anymore today. These points have been reiterated by the Security Council and the General Assembly on numerous occasions concerning Israel's obligation to withdraw from the occupied territories. France calls out, in particular, Israel's annexation of occupied territory. Quote, "The status of occupying power does not confer any legal title justifying annexation. The passage of time is not sufficient as regards the acquisition of territory by force to render lawful a situation that is gravely unlawful. On Israel's vast network of settlements and hundreds of thousands of settlers in the occupied territory," France states, "these permanent establishments are obviously incompatible with the necessarily temporary character of the occupation." 35 of the states and international organizations that submitted written statements addressed to the legality of Israel's occupation, 35 of the states and international organizations have addressed the legality of Israel's occupation of Palestinian territory. Only 2 of these 35, to which I will come, argued that the occupation is not unlawful. Key excerpts reflecting the views expressed by the overwhelming majority that the occupation is unlawful as a whole and must be brought to an end are collected in Chapter 2 of the State of Palestine's written comments. Here are 3 brief but emblematic examples. The African Union, quote, "invites the court to conclude that the prolonged Israeli occupation of the Palestinian territories is in itself unlawful. The policies and practices associated with it amount to de facto and de jure annexation of the Palestinian territories, which violates the prohibition on the acquisition of territory by force." Brazil observes that, quote, "occupation is inherently temporary. This is the basic distinction between occupation and annexation." Brazil here hits the nail right on the head. Unlike occupation, annexation is intended to be permanent, and it makes the occupation itself unlawful. In Brazil's words, Israel's policies and practices render the occupation unlawful as a whole inasmuch as it would be tantamount to the acquisition of territory by force. Japan, too, emphasizes that the annexation of occupied territory is unlawful, referring to Article 2.4 of the UN Charter. Quote, as the ICJ clarified in the Wall Advisory Opinion, the illegality of the acquisition of territory by force is a corollary of the prohibition of use of force incorporated in the UN Charter, which Japan calls, quote, the most fundamental rule of the post-war regime for peace based on the rule of law among nations. The two outliers are Fiji and the United States. Of all the states that submitted written statements to the court, only Fiji attempted to defend the occupation as lawful. But even Fiji conceded that Israel has annexed East Jerusalem de jure, and that the application of an occupying power's laws to the occupied territory, which is the case in the West Bank, constitutes an annexation de facto. Nor did Israel itself deny its annexations of Jerusalem and the West Bank. Its abbreviated written statement is mainly an attack on the General Assembly for its alleged bias. It makes no attempt to defend the legality of its occupation under international law. The only state besides Fiji to defend Israel is the United States. This is not surprising. Whatever offenses against international law Israel commits, the United States comes forward to shield it from accountability. Here, the United States attempts to defend Israel not by arguing that the occupation is lawful, but that it is neither lawful nor unlawful. To reach this conclusion, the United States argues that belligerent occupation is governed exclusively by international humanitarian law and not by the UN Charter or general international law. In its own words, quote, although international humanitarian law imposes obligations on belligerents in their conduct of an occupation, it does not provide for the legal status of an occupation to be lawful or unlawful. Even assuming arguendo that this is a correct reading of international humanitarian law, which we dispute, it does not lead to the conclusion that an occupation cannot be unlawful under international law. What about Article 2.4 of the UN Charter and general international law, including the prohibition on acquisition of territory by force? For the United States, apparently, this peremptory norm does not exist when it comes to Israel's annexation and settlement of the occupied Palestinian territory. Only in such a lawless and UN charterless world could the Israeli occupation be described as not unlawful. Notably, the United States ignores the part of the General Assembly's request that the court determine the legal status of the occupation under the UN Charter, in addition to IHL and other sources of law. And the U.S. fails to mention, let alone respond to, Switzerland's written statement asserting that belligerent occupation is covered both by IHL and by the UN Charter and general international law, and that the legality of the occupation itself is governed by the latter. The United States also ignores the written statements of the many other states which conclude that the Israeli occupation is unlawful as a whole, precisely because its annexation and settlement of the occupied territory constitutes a permanent acquisition of territory by force in violation of Article 2.4 and general international law. Instead, in a single footnote, the United States responds only to those states which submitted that the Israeli occupation is unlawful under Articles 40 and 41 of the draft Articles on State Responsibility for Internationally Wrongful Conduct. Remarkably, the U.S. contends that neither of those two articles reflect general international law. This is truly stunning. A persistent failure of a state to fulfill an obligation arising under a peremptory norm is not unlawful under general international law as provided in Article 40. The injunction in Article 41 that no state shall recognize as lawful a situation created by a serious breach of a peremptory norm is not part of general international law. Just how far, in disregarding the international legal order, will the United States go to exempt Israel from the consequences of its ongoing violation of peremptory norms, including the prohibition on acquisition of territory by force? Apparently, very far indeed. According to former U.S. President Barack Obama, in the memoir he published in 2020, just about every country in the world considered Israel's continued occupation of the Palestinian territories to be a violation of international law. As a result, our diplomats found themselves in the awkward position of having to defend Israel for actions that we ourselves opposed. This is exactly what the United States is doing, again, in these proceedings. Mr. President, members of the Court, the evidence is before you. In the written submissions of the State of Palestine and dozens of other states and international organizations, and in the voluminous materials supplied to you by the Secretary General, and it is indisputable. Under the umbrella of its prolonged military occupation, Israel has been steadily annexing the occupied Palestinian territory, and it continues to do so. Its undisguised objective is the permanent acquisition of this territory and the exercise of sovereignty over it in defiance of the prohibition on acquisition of territory by force. The evidence is not only indisputable, it is of the highest probative value. Investigative reports of authoritative United Nations agencies, reports of the Secretary General, resolutions of the Security Council and the General Assembly, legislative and administrative acts by the Israeli government, and public statements against interest by the most senior government officials, admitting that Israel's objective is sovereignty over all the territory east of the Green Line and its incorporation into a single Jewish state from the river to the sea. In this case, there is no reason not to take them at their word, because their deeds have been entirely consistent with it. For Israel, as its successive governments have made clear, there is no Palestine. It simply does not exist. In November 2023, Prime Minister Netanyahu declared that his government would never agree to a Palestinian state in the occupied territory. He later declared, "I will not compromise on full security control over all the territory west of Jordan, and this is contrary to a Palestinian state." Israel's intransigence was confirmed by its staunchest ally in December 2023, when U.S. President Joe Biden publicly lamented that Israel's leaders, quote, "don't want anything remotely approaching a two-state solution." That is the very solution demanded by the Security Council, the General Assembly, the overwhelming majority of states, and the State of Palestine itself. It is, in fact, the only solution that can lead to lasting peace and security for the Israeli people, as well as the Palestinian people. And it is this very solution that has been frustrated by Israel's defiant insistence on maintaining its dominion over Palestinian territory in perpetuity. This is why the Court's advisory opinion is so critical and so urgent. The best, and possibly the last, hope for the two-state solution that is so vital to the needs of both peoples is for the Court to declare illegal the main obstacle to that solution, the ongoing Israeli occupation of Palestine, and for it to pronounce in the clearest possible terms that international law requires that this entire illegal enterprise be terminated, completely, unconditionally, and immediately. Mr. President, the law is clear and it demands nothing less. A permanent occupation, one that is founded upon annexation and massive settlement of the occupied territory, and which aims to exercise sovereignty over it, is manifestly and gravely unlawful. It is an ongoing international wrong that must be brought to an immediate end. As the Court ruled in 1971, quote, the continued presence of South Africa in Namibia being illegal, South Africa is under obligation to withdraw its administration from Namibia immediately and thus put an end to its occupation of the territory. The Secretary General applied this principle directly to Palestine in his remarks to the Security Council 1 month ago. Quote, Palestinians must see their legitimate aspirations for a fully independent, viable, and sovereign state realized in line with United Nations resolutions, international law, and previous agreements. Israel's occupation must end. End of quote. Mr. President, the proverbial ball is now in your court. The General Assembly has asked you the critical questions. It is now your responsibility to answer them. Silence is not an option. As the immortal Palestinian poet Mahmoud Darwish wrote, in silence, we become accomplices. But, he assured us, when we speak, every word has the power to change the world. Mr. President, members of the Court, your words have such power. In 2004, the Court affirmed the inalienable right of the Palestinian people to self-determination. In 2024, it is time for you to enable them, finally, to exercise that right by freeing them from the unlawful Israeli occupation of their territory, so that they may live in a sovereign and fully independent state of their own, in peaceful and secure coexistence with all their neighbors, including Israel. By upholding international law, which is all the state of Palestine asks you to do, your powerful words will change the world. I thank you, Mr. President, members of the Court, for your kind courtesy and patient attention. We're in your hands, Mr. President, whether you would like to take the mid-morning break now or call our next speaker.
I thank Mr. Reichler. I invite the next speaker to take the floor after a coffee break of 10 minutes. The sitting is suspended.